Madam Deputy Registrar, can you please commence the proceedings?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction on appeal from the Court of Appeal of Guyana, judgment delivery in GYCV number 7 of 2021 between the Commissioner of Guyana Geology and Mines Commission and the Diamond Quarry Incorporated and Baraca Quarry Incorporated. The members of the delivery panel are Mr. Justice Saunders, President and Presiding Judge.
Good afternoon, Council.
Mr. Justice Witt.
Good afternoon, Council.
Mr. Justice Anderson. Madam Justice Rajnatley.
Good afternoon, Council.
And Mr. Justice Burgess.
Good afternoon, Council.
May we have the appearances, please? Thank you.
May it please Your Honours, Kamal Ramkaran, appearing in association with Harry Ramkaran, Senior Counsel, for the appellant.
Good day, Your Honours. If you please, Timothy Jonas. I am led by Mr. Edward Laku, Senior Counsel, and with us is Ms. Maria Laku, for the first respondent.
Yes, good afternoon again, Council. In this matter, the court has reached a unanimous view. The judgment is authored by Mr. Justice Anderson, and I would invite him to read a summary of the judgment. Justice Anderson, are you with us?
President, I don't know. I think he fell out of the grid. If he's in court, let me try to get him.
Yes, if you can just give us a second or two.
Thank you. President, I'm seeing the grid, but we're not seeing nor hearing him. May we take a moment to see whether we can connect with him, please, sir?
Okay, I would see if I could get him on the phone.
Thank you.
and we're seeing you. So I think we are all ready to go. So good afternoon again, Council. And as I indicated, our judgment in this matter is a unanimous one. It's authored by Mr. Justice Anderson, and I will invite him now to give a summary of the judgment.
Thank you, President. This summary is not intended to be a substitute for the reasons of the Caribbean Court of Justice or to be used in any later consideration of the court's reasons. The Guyana Geology and Mines Commission, the Commission, is the statutory body with power to grant and renew quarry licenses in Guyana. On 28 March 2014, Diamond Quarry Inc., the first respondent, applied for a quarry license pursuant to Section 89 of the Mining Act, Cap 6501, in respect of 848 acres of land in an area of the interior of the country known as Monkey Jump. Prior to the application, the first respondent did the necessary research to satisfy itself that the land applied for was not legally held or applied for by anyone. On 19th July 2014, the Commission surveyed Monkey Jump, and on 15 September 2014 issued a cease work order against Baraca Quarries Inc., the second respondent, in respect of its occupation of a portion of Monkey Jump for which the first respondent had applied. The land administration manager of the Commission represented to the first respondent that the application would be processed as soon as the statutory documentation was submitted and verified. On 16 September 2014, the Commission published in the Official Gazette a notice of intention to grant a quarry license to the first respondent. The notice required that any person claiming any right or interest in the area to be granted lodge with the Commission a petition objecting to the grant of the license within 21 days of publication. No one lodged an objection within 21 days or at all. On 15 October 2014, the Commission requested and was supplied with additional documents pursuant to the mining regulations Cap 6501. The Commission indicated to the first respondent that it had favorably considered the first respondent's application. Just over 3 months later, at a meeting convened by the Commission on 10th February 2015, the Commission stated that many years earlier, the second respondent had applied for the same land for which the first respondent had applied. The report of the meeting, compiled by the Commission's Land Administration Manager, represented that the Commission had accepted 2 quarry license applications for the same land, and that the land would be subdivided between the first and second respondents. The first respondent applied to the High Court of Guyana, alleging that the Commission's decision to subdivide the land was grossly unfair, discriminatory, and based on mala fides and favoritism. The second respondent was not a party to the High Court proceedings, but the Commission submitted an affidavit in answer sworn by its Land Administration Manager, alleging that a portion of the area for which the first respondent had applied had been occupied and quarried by the second respondent for several decades. Chang CJ, acting on 12 March 2015, granted an order of certiorari directing the Commissioner of the Guyana Geology and Mines Commission, the Commissioner, to quash the decision to subdivide the land for which the first respondent had applied. 2, an order of mandamus directing the commissioner to grant the first respondent a quarry license over the said land. And 3, an order of prohibition preventing the commission from granting a quarry license to any other license to any other person or corporate entity in respect of the said land. The commission appealed to the Court of Appeal, and the second respondent applied for and was granted leave to intervene. The second respondent deposed that it occupied the land applied for by the first respondent for over 50 years, that the land was home to 12 of its employees, and that it had undertaken substantial infrastructural work on the land. The second respondent also deposed that in 2006 it made a monkey jump license application, but that the publication was in error in that the coordinates gazetted by the commission were different from that contained in its monkey jump license application. The Court of Appeal dismissed the appeal and upheld the decision and orders of the Chief Justice in all respects, except for the order that the commission issued the license to the first respondent. Instead, the Court of Appeal remitted the application to the commission for its consideration according to law. However, the Court of Appeal made clear that the first respondent was entitled to the license as a matter of fact, and that the second respondent had no legitimate expectation to the land. The second respondent did not appeal this decision. The commission appealed to this court against the entirety of the judgment of the Court of Appeal. The first respondent cross-appealed only that part of the judgment of the Court of Appeal relating to the decision to set aside the High Court's order of mandamus, directing the commission to issue or grant the license to the first respondent. The second respondent did not enter an acknowledgement of service and took no part in the proceedings before this court. This court considered 4 issues, namely 1, whether the second respondent had applied for the same land for which the first respondent had applied. 2, whether the commission had made a decision to subdivide the land. 3, whether the first respondent had a legitimate expectation to be issued a quarry license. And 4, whether the first respondent was entitled to an order of mandamus directing that a quarry license be issued to it. The court held first that the 848 acres of land for which the first respondent had applied to conduct quarrying operations had not been the subject of an application for a quarry license by the second respondent. It appeared clear from documentary evidence proffered by the commission that the second respondent applied for 1,200 acres in Monkey Jump, but that this was to the north of the 848 acres applied for by the first respondent. On the issue of the subdivision, the court concluded that even though this was an issue which would have benefited from cross-examination, there was enough in the documents and surrounding circumstances to reach the determination that on a balance of probability, the commission had made the decision to subdivide, and that the first respondent was always displeased with that decision. The court next considered the doctrine of substantive legitimate expectation. The court held that where a public body gave an unambiguous assurance to a claimant that the claimant would enjoy the substance of an existing policy, it would be unfair to the claimant to allow the public body to change or abolish the policy unless some overriding public interest was shown to justify the change. In the present case, the first respondent had received the unequivocal assurance from the Commission that its application had been favorably considered and that the notice of intention to grant the license would be published. That notice was published, and there was no objection to the grant of the license by anyone, and no claims of public interest have been proffered to justify frustrating the first respondent's expectation that it would be granted the license. Finally, the court noted that a finding of substantive legitimate expectation did not always warrant the grant of mandamus to give effect to that expectation. However, in cases where there was only one lawful outcome, a mandatory order could be given to require that result. The court considered that the course of conduct between the parties and the written assurance given by the Commission represented a clear and unambiguous promise from which the Commission could only resile for reason of some overriding public interest, and that no such reason had been presented. The only lawful outcome was therefore the grant of the license to the first respondent. Accordingly, the court dismissed the appeal, upheld the cross appeal, and issued consequential orders. 1, affirming the orders of Chang CJ acting. 2, reaffirming the cost order made in the court below. And 3, ordering the Commission to pay to the first respondent the costs of this appeal. Thank you, President.
Yes, thank you very much, Justice Anderson. So that is the judgment of the court. Well, a summary of the judgment of the court. Is there anything from counsel?
No, no, not from me, Your Honor.
Yes.
Not from the first respondent, Your Honors. We're very grateful.
Okay, thank you very much. That concludes our hearing. Madam Deputy Registrar, can you please close the proceedings?
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnapli. Thank you, Mr. Justice Burgess. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.